Holmes, case number 12 CR 1522, and the record should reflect that Mr. Holmes is present with his attorneys, and some of the prosecutors are present. Let's see, Mr. Orman, Ms. Tish McGuire, and Mr. Edson are present, and we are outside the presence of the jury. Let's take up the emails first. Did you have an opportunity to talk, Mr. Orman?
Actually, we emailed.
The email, sorry. Yes.
We emailed.
Oh, you emailed?
Yes.
So the communication was through email about the emails?
Yes, Your Honor.
All right. And have you come to any agreements or?
Well, I think that we know where the disagreements are. And actually, we spoke and then emailed. Speaking with counsel, I think that they have some overall objections to the totality of the emails and then specific objections to some of them. And I think we're just going to have the court decide.
All right. So we'll start with you, Ms. Spengler. Tell me what the objection is, please. And what is this exhibit marked as, so that the record is clear?
I hadn't thought that far ahead, Your Honor. I'm sorry. I don't know what we've got it marked as. I'll figure that out.
Okay.
Ms. Huntsman will get that number for us shortly.
All right.
Judge, the defense's overall objection to the content of these emails and these emails as a whole is primarily relevance. The court has heard before, we do not believe that the content of these emails are relevant to the issue of sanity or to any material issue in this case, and as a result, the probative value is substantially outweighed by the danger of unfair prejudice or confusion of the issues for the jury to review these emails sometime in the future during deliberations. The emails contain hearsay. I'm concerned that the emails that are contained within this batch contain hearsay, that a limiting instruction is not going to sort of resolve or adequately deal with. Several of these emails within this batch are from witnesses who we either haven't heard from, have already heard from, meaning they've already testified and they've been released, or their names simply haven't come up and are not relied on by any experts. And as I said, will not be testifying in this case, so there is a confrontation issue. And we also would assert that the admission of these emails will violate Mr. Holmes' right to due process. The prosecution has not asserted in any of their arguments regarding these types of emails, or regarding emails in this case, that any expert particularly relies on any communication in the time leading up to the events of July 20th as it relates to sanity. And so I think that also reduces the probative value and creates a situation where the prejudice does substantially outweigh the probative value. They're not being presented to rebut any defense evidence because the defense hasn't presented any evidence at this point.
Hold on a second. Mr. King just stepped out. We're having this discussion now at his specific request because he said he was lead counsel and we could not have this argument without him. So he better be here. I changed my schedule at his request. He better be here. All right, Mr. King has stepped back in the courtroom.
Sorry, Judge, I had a phone call. That's my phone call.
Okay. Ms. Spengler?
Thank you, Judge. So because there is no identified expert or witness who relies on these emails or these exchanges as part of the basis of their opinion, that's another reason why the defense is asserting that the probative value is reduced to a point where it is substantially outweighed by the danger of either confusion of the issues, cumulative evidence, or the danger of unfair prejudice overall. Judge, additionally, we just assert that the assertion of a defense but not guilty by reason of insanity is not a gateway to open up an individual, Mr. Holmes in this case, to all of his statements becoming relevant for purposes of trial. And I know that the court has found some testimony and some emails to be relevant, and that his communications do have some relevance and have admitted emails from professors, exchanges between Mr. Holmes and his professors, as well as testimony from those professors and from students at the University of Colorado. So I believe at this point, any additional communication, any additional testimony would be also cumulative to that information that's already been introduced and allowed by the court. Now, Your Honor, I also have specific objections. We're objecting overall to the entirety of the exhibit, but I also have some specific objections to some of the specific language within several of the emails. I will characterize these phrases or this language that we're objecting to as possibly 404, possibly inadmissible character evidence, and I will be upfront with the court that it doesn't. These phrases don't necessarily fall directly within, inadmissible character evidence, but because the relevance of the email is so low, because it doesn't go to any material issue, I think the fact that these phrases can invite the jury to speculate and can be confusing, it really substantially outweighs any probative value, and that's why I'm drawing the court's attention to these specific phrases or specific emails, and I'll do that now if that's okay with the court.
Yes, please.
Okay. August 23rd, 2011, there's an email exchange between Mr. Holmes and his father, Robert Holmes. And there's hearsay contained within the statements of James's father about his sister. I think that can be characterized as double hearsay, and I also think it can be characterized fairly as character evidence related to his sister, Chris, which simply is not relevant. And we would specifically object to that email on that basis. Your Honor, October 30th, 2011 is the second email I draw the court's attention to.
I'm sorry to stop you. Is there just one email that's dated August 23, 2012, or do you want to tell me the specific phrase or language that you're concerned with?
And it's August 23rd, 2011, and I can... I believe there's only one email on that date, but I can direct the court to the last paragraph or second paragraph.
Just for suggestion, make it easier for counsel and the court to refer to the emails, I would note each of these emails has a Bates number at the bottom.
Oh, okay.
So it may be easier for counsel just to tell the court if the Bates number specify. That's just a suggestion that I noticed.
Okay, thank you.
That's a good idea. So that would be page 1359, and that would be the second paragraph of James's father's email to his son. Then I'd refer the court to an email dated October 30th, 2011. I'll just have to get there, which is stamped 2964. Your Honor, in this email, there's a reference to speeding and to police being lame. Again, probably not inadmissible character evidence or 404 in and of itself. Possibly. I'm not going to concede it's not. But there's no relevance, very limited relevance to this email, and I just think that the reference ends up not surviving a 401, 402, 403 balancing test. November 15th, 2011, there's also a reference to traffic school, and I would make the same objection with the same record as I just did for the October 30th email, but let me get that number for the court. That would be 3297 is the page number at the bottom. December 9th, 2011 email. Simply, it's a question about Mr. Holmes' correct date of birth. Again, seemingly, I suppose, insignificant, but there's no relevance to the email, and why draw the juror's attention to the fact that the university may have had two dates of birth for Mr. Holmes. I just don't see any relevance and would object specifically to that email. January 16th, 2012, there's an email exchange, or excuse me, an email that is initiated by one of Mr. Holmes' professors who we have not heard from, Diego Restrepo. And that is hearsay. We have not heard from that individual. We would not be able to confront that individual, and there is writing contained within a written document, what appears to be homework, and we would object specifically to that. I'm going to take my hand off of the speaker and look for the page number. That would be page number 4456 through 4458. Your Honor, there's January 31st, 2012 email. Page number 5334. This is a period of time where there's a sort of series of emails where Mr. Holmes appears to be looking for a third rotation and a lab in a third rotation, and there is a reference to the work that this particular professor does on impulse aggression disorder. I just think it's not relevant and has the potential of being prejudicial and does not survive a 403 balancing test. There's a February 7th, 2012 email exchange with Kurt Fried. The court knows we've already heard from Professor Fried or Dr. Fried. That would be at page 5623. The content is generally benign, Your Honor. It's simply scheduling. But there is a reference to doing rat transplants. And again, if it's just an email about scheduling, I don't see the relevance to any material issue in this case. So why inject rat transplants or information about that through this email? Again, we don't believe it survives a 403 balancing test. The same objection relates to the next email that I'll identify, February 13th, 2012, with a page number of 5747, and this refers to the attachment to that email. It's an email where Mr. Holmes purportedly is submitting a paragraph to his school regarding a summary report to the National Institute of Health, and it references in vitro experiments on rat brains. Again, I just don't believe it survives a 401, 402, 403 balancing test. The specific objection, Your Honor, is to the content or the sentence contained within the summary report. It's not contained in the email itself. It's contained within the attachment. February 15th, 2012 is actually just a continuation of the email I referenced already, the February 7th, 2012 email, so that email also contains a reference to rat transplants. Otherwise, just deals with scheduling, and that's at 5781, and that's a multi-page email. And contained within that is that reference. Your Honor, there's a February 19th, 2012 email that has a page number 5919, and this is a very brief exchange between Mr. Holmes, purportedly, and Cammie Kennedy, an administrator at the university, another individual we have not heard from, who has not testified, and it just deals with Mr. Holmes's billing statement, and I just don't see the relevance. It's short. There appears to be an issue with the billing statement. It contains hearsay. There's a confrontation issue. The relevance is obviously very limited, and I just don't know why we need to draw the jury's attention that Mr. Holmes's tuition was being paid for by the state of Colorado. I believe it's inflammatory, and the probative value does not outweigh that potential inflammatory effect. And I just have two more, Your Honor. Three more. February 23rd, 2012 is also that same scheduling exchange with Professor Fried that we've heard about. I'm going to take that back. I think it's a different scheduling issue with Professor Fried. That's at 6101, but it's also referencing work that the lab is doing with rat brains. Your Honor, March 26, 2012, I draw the court's attention to with a specific objection. It's regarding bad access, and I don't see the relevance. It is a single sentence to a witness who has not testified. It's not a witness's name that I'm familiar with, and I don't believe any of the experts rely on this email or on this particular individual who's involved in the email exchange, or it's not even an exchange, it's a single email to a Mary Mock about a badge access. And then finally, Your Honor, May 16th, 2012 is a email between Mr. Holmes and Professor Fried And attached is a PowerPoint, which appears to be the third rotation presentation, or at least some iteration of his third rotation presentation. As the court knows, the jury has already seen a portion of the presentation on video. Dr. Freed has already testified, and we now do not have the ability to confront on this email and what's the contents of this email. We do not know that this is the final presentation, so we would object specifically to that email and its attachment as well. Your Honor, that's all I have.
Okay, thank you. Mr. Orman, response? I'm not sure what happened to the microphone that was,
I'll use the, it's right inside the podium.
oh.
Well, Your Honor, in the global sense, the emails are being offered for the defendant's statements contained in the emails. There are statements by other people that the defendant responds to in most of the emails. There are a couple, and I say a couple, maybe 3 or 4 emails where they're just emails sent by the defendant. One of them is the one that counsel just recently mentioned about the badge access, was not in response to anything. The statements of other people, for instance, the statement that was mentioned about the defendant's father, are not offered for the truth of the matter asserted. They are offered to put the defendant's responses to those statements in context so the jury can understand what the defendant's statements are responding to and understand what they mean because of that. The totality of the emails, Your Honor, is relevant to the issue of sanity. I would note that the emails that we've placed in this exhibit, oh, and Your Honor, that the exhibit number you were asking would be 1227.
Well, thank you.
The emails that we have placed in here start on August 5th, 2011, and the final email in this is June 13th, 2012. So they span a period of less than a year, but they span most of the period where the defendant was at the University of Colorado, Denver, and demonstrate, Your Honor, his state of mind during that period of time, the way that he decides to use words, his thought processes, and that is probably the most important part of it, is the way he's able to think, the way he's able to process information, the way he's able to respond to queries, the way he is able to share information with other people, the way he is able to accumulate and put together information, Your Honor, is relevant to his mental state, mental processes, and the issues related to his plea of not guilty by reason of insanity. This is especially so, Your Honor, because of the assertion that the defense has made, and I believe it was an opening statement, that the defendant went through some type of degeneration, that's my word, of his mental acuity and mental abilities in the spring of 2012. This is evidence that shows exactly what his, well, not exactly, I guess, but it's good evidence, Your Honor, of his mental acuity, of his thought processes, of his connection to reality during the relevant time period. And regardless of whether an expert or experts have relied upon these emails to any extent, frankly, it's not the question, Your Honor, because the experts in this case do not decide the question of whether the defendant meets Colorado's test for legal insanity. That decision is made by the jurors. That decision is made by the jurors who will get, if this is admitted, to review this evidence, to see this evidence, and to make up their own minds about the defendant's state of mind and any changes in his state of mind during the time period from August of 2011 through June, or the early part of June in 2012. So that is my, I guess, argument about the totality of the evidence. And if Your Honor wants, I'll go through the individual ones that the defense made, unless you want some more argument about the totality.
No, it's up to you, whatever arguments you want to present.
Okay. Well, I appreciate that, Your Honor, but I know on numerous occasions you have had questions for me, so I wanted to make sure you didn't have any questions for me on that.
I don't. I'm going to have to review them over the weekend now that I know what the specific objections are and now that I know what the specific emails that are being objected to are.
So, Your Honor, regarding the email on August 23rd, 2011, which is Bates numbered 1359, and when I say that, Your Honor, all of these say CU02-00, and then they have the four-digit number. I'm just going to use that last four digits, if
All
that's
right.
okay with the
And
court.
don't feel like you have to go through each email one by one. You can make whatever arguments you want. I'll leave it up to you. So if you
Okay.
want to pick some, you can pick some. It's up to you. If you want to argue about all of them, you can argue about all of them.
Okay.
As I said, I will review them over the weekend and we'll consider whatever arguments the parties present.
I understand, Your Honor. I think I'll go through the ones that are sort of the different arguments that then have been previously made. One of the ones that counsel mentioned was the birth date email, which is on December 9th, which is page number 3987 from the Bates numbers, where the defendant is responding with his date of birth. Again, you know, Your Honor, this may seem trivial, but it is the defendant responding to a query, processing information, and providing the information in an appropriate, reasonable format for response, which I believe is relevant to his state of mind and to his mental processes and the issues of sanity. The email that is referred to from January 16th, Your Honor, and there's two of them sort of in here, and for some reason they did not show up as a chain of emails like we often see, where there's one email on the same page and the response on the same page. If you look at it, Your Honor, on January 16th, on page 4456, is the email of that Mr. Restrepo or Dr. Restrepo sent to the defendant with some CCs in here. And attached to that, Your Honor, the next page, 4457, is his write-up of this, and then 4458 is just sort of the last page saying it was sent from an iPad. The defendant's response, Your Honor, as I read it, is on the next page, 4459. And if you look at it, Your Honor, you can see that there is a portion of the email without the attachments, which has the same time as the email on 4456. So that indicates that the defendant is responding to that. And here, Your Honor, the defendant is responding to a criticism, and I say that in the sense of a professor grading work, essentially, of the defendant's work, and the defendant is responding to that. And this is in January of 2012, which again shows his thought processes, the way he processes information, the way he can put this together, and to me, Your Honor, is relevant to the issue of sanity. Your Honor, the 5354, which is January 31st, the objection on that is a reference to research that this person is doing on impulsive aggression disorder. I mean, if it were research on schizophrenia or something, that might be one thing, but this is not any type of disorder that I have ever seen in any discovery associated with this case, apart from this email. And the defendant is, it's not like an indication of anything other than the defendant is interested in working in this guy's lab and has put down what the type of research is. In fact, if you look at the next page, which is also January 31st and is 5336, you can see the defendant is using some type of essentially a form letter where he'll take most of the same language and then insert, here's your name, here's the type of research you're doing. So I just don't see any prejudice to the defendant, and it shows his state of mind, ability to process information, and how he does that. The email on February 13th, Your Honor, which is 5747, Your Honor, has attached to it what appears to be, if you read the email, work product, and I don't say that in the sense of attorney work product, I mean that in a general sense, of the defendant, something he wrote on what appears to me a very complicated scientific concept in February of 2013, which goes to his state of mind, ability to process information. '5919, Your Honor, which is February 19th, 2012, there's a reference to the defendant discussing financial issues relating to his education. Shows, again, his state of mind, his ability to understand the world around him, to respond to questions, and is part of the progression of time. And it's a snapshot in time along this continuum of time that the jury should be able to consider relating to his mental state and ability to understand the world around him and his attachment to reality. You know, there's one that I have marked in here, but I just can't find it as I'm flipping through. It's the, well, before I get to that, the last one that counsel objected to, Your Honor, is fairly late in this email stream of May 16th, 2012, and it's page 8587, and this is the PowerPoint that the defendant put together. And yeah, sure, maybe we've seen some clips of video of a PowerPoint, and maybe we don't know which version it is. Which version this is, Your Honor, is not the question. The reason this is relevant is because this is something that the defendant himself would have put together in May of 2012, a time period that is just a little over 2 months from the date of offense in this case, shows that the defendant's ability to put together information in a fashion that is connected to reality and is relevant to the issue of sanity. There was one more, Your Honor, about a traffic ticket, and I think I skipped it. I know Your Honor knows which one it is. Your Honor, there's no prejudice, and I don't really think counsel was arguing that a traffic ticket is inherently prejudicial in a case of this nature. But the way the defendant responds to that issue, the way he responds to the query, I believe it's from his mother, about that situation, again, Your Honor, is part of the continuum of time, shows his ability to understand events, to respond in a logical and coherent fashion. And this is evidence that the jury should be able to consider in determining the issue of sanity. And unless you have any questions for me, Your Honor, that completes my argument.
Is that the same speeding incident that has been talked about, or is that something else?
I believe it's something else, Your Honor. The speeding incident that we've talked about, I think, was in June. It may have been in May of 2012. This one, I believe, was in 2011. The second email that counsel mentioned about speeding may have been that incident, because there was 2 of them.
No. Both references to traffic ticket and speeding deal with the 2011 event.
So not something that we've heard about?
Correct.
Okay.
I appreciate that clarification from counsel.
All right, thank you.
Yeah.
All right, I will take a look at the exhibit over the weekend, and we'll consider all of the objections and then rule on them on Monday. All right, in terms of scheduling, that's the other thing we tabled until now. When we spoke about this a couple of weeks ago, what I said was that the prosecution gave an estimate at the beginning of trial, actually before the trial, that they believed they could put on their case in 2 months. And there are a couple of different ways you can look at what 2 months means. One is 8 weeks. The other one is actually just forwarding 2 months and then picking that same specific date. So if you go by the first calculation, 8 weeks, which would be my calculation, you would land on the 23rd of June. That's a Tuesday. That's the 8th week since the prosecution started putting on evidence in this case. The prosecution started presenting its case on April 28th. If you do the other method and just say, well, 2 months from April 28th is June 28th, that would fall on the following week, and it would be, I think that falls on a Sunday, and so the 29th would be the date, and that's a Monday. And what I had stated a couple of weeks ago is that my preference would be that we try to use the 23rd, Tuesday, June 23rd, as a deadline for the prosecution to finish its case, I think Mr. Brockler had advised the court at that time that in all candor, he wasn't sure if that was going to happen, but that, at least as I understood his comments, he was, I think, fairly confident that he could do it by the following week. And so what I told Mr. King was that at least as of a couple of weeks ago, he should plan on starting his case probably on June 30 or somewhere around there. June 30 or July 1st perhaps even. But that we would talk about this further today, and that was at the request of the people. The people said they would be in a better position to address this today as opposed to 2 weeks ago. So, Mr. Brockler, where are we? Do you think it's going to take you 2 weeks or 3 weeks to finish your case? You can either go to the podium or, yeah, thank you.
I'm sorry. I think right now, Your Honor, we believe that we can be done 2 weeks from today. And if I just said something crazy, someone around here will tell me that. I'm sorry? Ms. Tish McGuire has said I should say the 23rd. But I think there may be a chance we're done on the 19th, but no later than the 23rd.
No later than the 23rd. I understood it. It's by the 23rd. All right. So the 23rd is a Tuesday. The question is, do we leave a little bit of time for arguments, the motions that may be made at the end of the people's case, or do we think that the defense can start with its case on June 24th? And I'm looking at the people too. How confident are you that you're going to be done by the 23rd and that we can take care of any motions on the 23rd?
I'm pretty confident we'll be done, Your Honor, but as the court might know, we can't control it all and not set in stone, but I'm pretty confident.
Okay. All right. Mr. King, can you start your case on June 24th? Yes. And the other question is, Mr. King, you had estimated that it would take you a month to put on your case. And when I say you, I don't mean just you, I mean you and your colleagues. And later you told me that given some of the witnesses the prosecution has called, that it's going to be less than a month. And so if you would give me a modified or revised estimate as well, please.
Yes.
Judge, I could tell the court that it would be my preference, just because we've set things up thus far, to begin on the 29th. It would solve a lot of logistical problems for us. If the court is insisting, I think we probably could make a go of it on the 24th or the 25th. I'll let the court know that my problem is, and to answer the court's second question, I'm estimating 2 weeks at this point, perhaps a little shy of 2 weeks.
Okay.
My problem is, Your Honor, is not with, we have a number of lay witnesses, the vast majority of which are local witnesses. Those people are not such a problem. The people that are in issue are the expert witnesses, both from CMHIP and from our retained experts who are in Chicago and Philadelphia, and trying to work around their schedules. And I've been trying to work with them, but they're very busy. So I think we could probably make it work if I could fill that week and into the first few days with the lay witnesses, and I can probably get the expert witnesses here late the week of the 29th is my guesstimate, if that's what the court prefers. As I said, my preference would be to start on the 29th, given the fact that we are ahead of schedule, and that my case I'm now predicting is about half as long as I originally predicted.
The problem with starting on the 29th is if the prosecution ends on the 19th, now we're taking 10 days off. And these jurors have put their lives on hold. I'm not doing that to them.
That would be 10 days or?
Days, right. Whatever I may have said, 10 days is what I meant. I'm sorry. So that would be 10 days, right? You want to start on the 29th?
The 29th would be the following Monday. That would be,
June 19th to June 29th is 10 days.
oh, yes, you're right, Judge,
Right.
including the weekends, yes.
Right. That's taking a whole week off. I'm not inclined to take a whole week off. So, as I said, this is a difficult thing that we've asked these jurors to do, and I think we owe it to them to move it along, and I appreciate the parties doing that so far, but I want to keep us ahead of schedule. So I understand your logistical concerns, especially with respect to your witnesses who are out of state. So I'll work with you. What if we start on June 25? If the people are ending on June 23, we could use June 24 for any arguments we need, or we could take June 24th off. You can start on June 25. That's only a few days that week, and then you can try to fill that the next week, it sounds like, and then start calling your experts at the end of that week of the June 29th.
I think that is workable, Your Honor.
Okay.
And I'm more than willing to try to do that. If I could just have till Monday to verify with my experts their availability. It looks like I spoke to Mr. Bishop, and he's indicating that it looks like they would be available during that time frame. So I think we're going to be okay, but I would just need to verify with them.
Great, I appreciate that. All right, that's the plan then. The defense will plan on starting its case on June 25. The people will plan on finishing its case no later than June 23rd. And then we have June 24th to play with if we need it for any work that we may have to do outside the presence of the jury.
Your Honor, I've been told that once Dr. Metzner concludes, when we know that part ends, if it's Tuesday or something, we will be able to give the court a precise date by which we'll be done. That's the biggest unknown right now.
So you're calling Dr. Metzner then on Monday?
That's the plan, yes, sir.
Okay, all right. But you're telling me right now that you're confident that you'll be done by June 23rd, right? Yes. All your colleagues are saying yes. I'm assuming that's a yes.
Yes, they were not the ones that recently got beat up, but yes, I will commit to that, yes.
Okay, thank you. All right. Anything else in terms of schedule? No? Anything else that we need to talk to? By the way, the one juror is running late and said that she would try to get here by 3:45, although traffic was bad. So as it turns out, if she gets here by 3:45, that would be perfect. If she's a little bit later than that, we'll obviously have to work with it. Anything else on behalf of the people right now? Mr. Brockler?
No, Your Honor.
All right. Anything else on behalf of the defense?
Yes, Your Honor, I just have a quick administrative
Yes.
matter relating to the exhibit numbers. I just wanted to be clear, and I can work this out with your staff as well.
Okay.
But going forward, we would like to make sure that when a defense exhibit is marked with a certain number and it's tendered and rejected and it's not ultimately admitted into evidence, we would like to make sure that we mark each of those with a court exhibit number, but that it also retain that same defense exhibit number, kind of the same way that, when a prosecution exhibit number 56 doesn't come in, it keeps that number. It's not like their internal numbering system changes or anything like that, and then it gets a court exhibit number. So that, just to help us keep track internally as well of the exhibits that we are marking and at least attempting to admit, if that's okay with the court.
Absolutely, and that's how we've been doing it, and that's how we should continue to do it, so that the record is completely clear.
Great.
About what exhibits were proffered and rejected, and then marked as a court trial exhibit as a result.
So I think we might have a little bit of confusion and some renumbering to do from this morning. Hopefully we'll be clear going forward, but
Okay.
Mr. King had a stack of those video clips that he had marked as 25 through 52 or something like that. And then we ended up making another exhibit 25, then we didn't admit that one, then we made another exhibit 25. So I can try to sort it all out with your staff, but I just wanted to make sure we were kind of clear on the plan going forward and just in terms of the numbering.
That's fine. That makes a lot of sense. Now, in terms of the exhibits that, the discs that you're talking about, Mr. King only used 2 of them. Do you want to still mark all of them?
Yes, I think, because we may be using them with other witnesses as well, so I think it makes sense to give each of those discs both a defense number as well as a court's exhibit number.
Well, my preference would be to mark the ones that you actually use. I mean, those are the ones you're moving to admit. You're not moving to just admit the whole thing without asking any witnesses any questions about them, right? I don't think that would be appropriate. So to the extent that what you're asking is that when you question a witness about a particular clip, that clip should be admitted into evidence, then it should be marked at that time with whatever defense exhibit number, and then we'll mark it as a court trial exhibit number as well to show that it was offered but rejected. Does that make sense?
I think so, yes. I think this morning, Mr. King did offer all of those clips into evidence, and they were all
Well,
rejected?
I think what
That's my
he said
recollection.
was that he was, at least the way I understood it, was that he was going to use them, or he might use some of them. Now, I don't think you get to just say, I have all these clips, I'm not going to ask any witnesses any questions about them, I just want to introduce them into evidence. I don't think that's the way that would work. So, to the extent that there are any clips that you want to use with any witnesses, and you want those admitted, then I think they should be marked at that point, and mark them as an exhibit, defense exhibit number, and as a court trial exhibit number. Now, if you want to mark them in advance, that's fine, as long as you keep track of whatever numbers you've used, so that when you get to other exhibits, we don't get the situation that we had earlier today, where he used a number that had already, or a couple of numbers that may have been used already.
So just so I'm clear, the clips, have all of the clips that Mr. King tried to move into evidence this morning been marked as court's exhibits yet?
They shouldn't have been. They shouldn't have been marked yet, and to the extent they were, then they have been improperly marked.
Okay.
I am only going to mark the ones that you actually use,
Okay.
because those are the ones that I'm understanding you would move into evidence, and I'm not going to require you to say every time we move it into evidence. I mean, it's up to you. If you want to do it in front of the jury, you can, but the understanding is, to the extent that you use it with a witness, I already know that you want to introduce it into evidence, and the record is clear that that's my understanding that any clips that you use with a witness, you want to introduce into evidence. And my ruling is you can use it with the witness in questioning the witness, but you cannot admit it into evidence. Any clips that you don't attempt to use with a witness, that they're just clips that you made copies of, those are not part of the record and should not be part of the record. So they should not, to the extent you want to mark them as defense exhibits on your own, you can in advance, but we should not mark those as court trial exhibits yet. Okay?
We'll put our heads together, and if, with the court's permission, if I, can confer with your staff, we'll get it sorted out and make sure we're all on the same page as far as numbers then.
Not only with my permission, it's my request. I want to make sure that we're all on the same page. So I'm glad that you brought it up.
Very well, and we'll obviously communicate it to the prosecution as well.
Thank you.
Just an observation that when we prepared our exhibit list, we numbered anything we thought we might use, some of which we're not using. So there's gaps in our numbering, and if the defense wants to use a similar system, we obviously don't object. We don't think everything has to be sequential.
Right.
They can be skipped.
Right. Okay. All right. Anything else? Mr. Brockler, any more sulking that you want to do?
Save that for this weekend.
You're lucky it didn't come down on you for talking so much about Justin Bieber, okay? And having everyone then talk about it as well. All right, we're going to be on break. As soon as the juror gets back, then we'll get started. The court will be in recess.